Ready, start. The petitioners therein had contended that levy of an additional amount only on unlinked consumers of the non core sector was discriminatory and violative of Article 14 of the Constitution, as the differentiation between linked and unlinked industries for the purpose of pricing was irrational and did not constitute intelligible differentia. It was also averred that such substantial price variation under the guise of an additional levy amounted to dual pricing, which was arbitrary and excessive. The High Court rejected these arguments and found no infirmity in the differential pricing adopted by the coal companies on the ground that the extent of bulk consumption of coal by the core/linked sector industries called for a special treatment. It was observed that the core sector consumers were afforded the benefit of lower prices due to their intrinsic importance in nation building activities and provision of services in the capacity of public utilities. Therefore, any substantial increase in the price of coal would have a ripple effect and adversely impact the end consumers' purchasing power, especially for goods and services that are consumed in bulk all over the country, with electricity, cement, etc. On the other hand, since consumption of coal by the non core sector was minimal as compared to the core sector industries, it would not result in an appreciable increase in the cost of the goods and services manufactured by the unlinked industries in the non-core sector. Thus, dual pricing could not be said to be irrational and hence arbitrary. Resultantly, this court, at the instance of the aggrieved writ petitioners, was faced with the controversy of whether the dual price fixation by classifying customers into core sector/linked sector and non-core sector/unlinked sector industries was irrational and was an instance of hostile discrimination. This court prefaced its judgment with the observations given in Cyanamide, India, within bracket supra bracket close, and Sitaram Sugar, within bracket supra bracket close, wherein it was held that price fixation is neither the function nor the forte of courts, and that the courts should not be concerned with pricing policy and rates fixed. The only situation in which the courts can inquire into the price fixation process and the result thereof is when the legislature has laid down the pricing policy and prescribed the factors that should guide the determination of the price of a commodity. Price fixation is generally a legislative activity. It may occasionally assume an administrative or quasi judicial character when it relates to acquisition or requisition of goods or property from individuals, and it becomes necessary to fix the price separately in relation to such individuals. Such situations may arise when the owner of the goods is compelled to sell goods to the government or its nominee, and the price is to be determined according to the statutory guidelines laid down by the legislature. In such situations, the determination of price may acquire a quasi judicial character, but otherwise, price fixation is generally a legislative activity. After observing this, the court held that price fixation is neither the function nor the forte of the court.